Well, good morning and welcome to today's webinar on recruitment and legal practices for recruitment. I'm Tim Kellett. I'm from Paydata, and thank you very much for joining today's webinar. I hope you find it useful. Just a bit of logistics. First of all the slides that you see here today we'll send out afterwards, so you get a copy of the slides today. We're due to have the webinar for an hour, and so we're going to try and do a hard stop at 11 o'clock. If there's any questions that at the end and we don't have time, we'll get to Anna to answer them, and then we'll send those out with the slides as well. So it's just a bit about who Paydata are. We're a reward management consultancy, and we support employers to find, attract, retain, and motivate the right sort of skills and talent to help themselves become successful. And where do we help organizations with that? Well, in a number of ways. The clue's in the name, Paydata. So we provide a lot of pay and reward information. So helping organizations to determine how competitive their reward practices are against the external market. We work around the whole foundations of rewards. So that's setting a reward strategy, helping design pay and bonus schemes through our consulting side. A lot of organizations need to work around how they organize their jobs into a hierarchy, and we have our own job evaluation system, where we help organizations to accurately assess the size of roles. We support the whole pay reviews, pay and bonus review process, and that's a significant amount of time involved. And a lot of people don't like using spreadsheets anymore, so we have our own bespoke online software to help with that. What's really interesting in the last sort of 18 months, a lot of people looking at pay structures and wanting to pay more transparently, more fairly, and more consistently. So it's using what you're currently paying, what the external market's paying, within the bounds of what you can afford, and creating a pay structure, salary scales, and things like that. We support a lot of the analysis of looking internally at the internal pay equity, and so we've been doing equal pay audits for over 20 years now. And then finally, part of what this is about is providing organizations with really useful and valuable business insights and specific research on reward practices, and hosting HR workshops in various sectors as well. So that's what we do, and hopefully you find today useful. As I said, I'm delighted to introduce Anna Fletcher, who is a partner at leading legal firm Gowlings, and Anna's done one or two of these webinars for us, and brings a whole wealth of knowledge from the legal perspective to our customers and our contacts as well. So today we're looking at the sort of whole legal landscape, the complex legal landscape, but in relation to recruitment and recruitment practices. So and we've had a really good take up today for people to join. So I hope you find it useful today. So welcome, Anna. I'm going to start things off just very briefly at the beginning with some stats around recruitment and retention, and some trends and what we're sort of seeing as sort of set the scene really. But then Anna's going to largely going to delve in looking at discrimination and avoiding that in recruitment, the power of reasonable adjustments as well, positive actions, also looking at things like equal pay risks, and also artificial intelligence, AI, and how people are looking at that in terms of recruitment from a legal standpoint. Then we've got employment law reform, and then finally, if there's any questions, we'll take those at the end. And as I said, if we run out of time and we sort of have the hard stop at 11, we'll make sure that Anna answers those questions, and then we'll send those out afterwards. So there, and then just to repeat myself, we will send out the slides for today with afterwards as well. So. And also, of course, this webinar is being recorded. So if any of your colleagues you think would find it useful, you can always send the link to them. So talking a little bit, first of all, about current recruitment trends. We collect a lot of information constantly about this, and I thought this would be a good way to start. So we can sort of determine how competitive the external labour market is, the recruitment market is, by looking at out-of-cycle increases. So this is where we ask organisations, you've had your annual pay increase, but then you've got the sort of knock at the door after that, where people are sort of saying, I'm going to move unless unless you pay me an increase. And we ask people to quantify as a percentage of their pay bill, what does that look like in terms of an increase? And we're excluding promotions. And you can sort of see, a dip in out of cycle increases as you'd expect around the sort of COVID times. We saw a big increase post COVID up until a sort of a high in 2022, and that was a lot of the Great Resignation, people talking about actually a bit of pent up demand. So a lot of recruitment and retention challenges there. And then obviously since then we've seen labour market pressures ease sort of overall. And when we talk to organisations through our HR workshops, they have said that the situation has perhaps somewhat eased a little bit overall, but that's not to say that there are some real hotspots in particular parts of the country and for particular sort of roles as well. So that's a sort of general trend in terms of retention and people having to pay to retain staff. When you look at actually retention and recruitment together, we ask organisations, we say, have you had recruitment difficulties or have you had retention difficulties in the last 12 months? And you can see we've been asking this question for quite some time now, and it follows a similar sort of pattern, I suppose, to the out of cycle increases where around COVID times really there wasn't a challenge around recruitment and retention. It wasn't the sort of focus there at the time, but we saw that great big that sort of recovery post COVID, and then we've seen that sort of slight decline in the percentage of organizations who've had recruitment and retention difficulties. What's interesting about this graph is that and this is backed up by our conversations with employers, that they find it harder to find the right skills than they do to retain the right skills. So actually you can see the orange line there. There's always a slightly higher proportion of organizations having problems recruiting than they are retaining people. So so there's obviously there's still recruitment and retention difficulties back end of last year as well. So that's recruitment and retention. If we look at just recruitment now, we are another way of gauging how competitive the external market is to look at sort of recruitment premiums. And we ask organizations, are you having to pay a premium to recruit your staff which conflicts with what you're currently paying your existing employees? And obviously everyone in HR sort of says recognizes the challenges this brings. If you're bringing someone in on a premium, that doesn't help the internal relativities, but sometimes with recruitment, needs must, and you have to pay a premium perhaps to bring in the right sorts of skills. So the graph on the left hand side is sort of saying what percentage of organizations are saying they're having to pay a premium. And again, you've seen that sort of a drop in that over COVID and then an increase post COVID into 2022, and then we've seen a sort of slight easing of that since then. But if you look at the graph and where we've ended up at the back end of last year, that's still half of organizations saying they're having to pay a premium to recruit a new starter, which sort of conflicts with what they're currently paying. We ask people then can you quantify what does that look like as a premium compared with what you're currently paying? What's the percentage there? And that's the and the graph on the right tells us what's that percentage really if you're having to pay a premium. And you can sort of see for the most part organizations are paying up to 10% as a premium, but you can see in different times, 2021 into 2022, that there was a higher orange bar there, and that's where people were paying sort of up to 20%. And we do see some variation for different sectors, and some sectors they've got a higher proportion of the orange bar, where there's just generally skill shortages in the market as well. So you can sort of see where we are at the moment. It's mostly up to 10% as a premium. It's sort of settled down since 2021, 2022. So that's recruitment premiums. And the other way of sort of gauging how competitive is the labour market is to look at the labour turnover stats, and we've got the sort of voluntary labour turnover stats here, and you can again we've kept those over time. Again, you've seen sort of a drop in labour turnover over sort of between 2019 and 2021. We sort of saw an increase post 2021, and then you can sort of see there, and then we've seen a sort of slight decline since sort of autumn of 2023, when there was some obviously some real recruitment challenges there as well. So again, overall, perhaps the voluntary labour turnover figures, although at this point in time we collected some data on this in January, that was fairly consistent with the autumn period. It's still, you know, it's still above the sort of 10% mark anyway at the moment, almost 11%. So. Okay, so just to sort of summarize what we're sort of seeing and talking to organisations, looking at the stats, I think overall the labour market pressures have eased since 2022, we're at the high then. But talking to different industries, there are some real competition for key skills. In some of our other surveys, 89% of employers state that they are experiencing labour shortages in the market. They are having challenges finding the right sorts of skills. 87% report a lack of suitable candidates, and that's the challenge. Obviously, that puts more pressure on people's recruitment processes, and you know, trying to bring people in as well. I think and as I said, employers tell us that they're finding it hard to find the right skills and talent rather than the retention side. And I think obviously we've had the sort of above average increases in the national living wage. So, you know, the national living wage has been going up sort of 9% historically. I think it's 6.7% this coming year. That's way above what annual pay awards have been. So that creates pay compression and again creates some challenges on recruitment. And same with the employers' NI contributions. That's really having quite a profound effect we found on this year's pay budgets, and that's limiting what people can do around their pay budgets. And so therefore there's a concern as well that actually if pay budgets come down, are we going to start to see people moving more because they're not getting the increases that they want? But does that then create more pressure on recruitment and bringing people in as well? So I think it's all intertwined, but obviously I think what our stats show is that there's still some real challenges in terms of recruiting the right sorts of skills, and obviously getting your processes in place and making sure that they're legally compliant is really important to that. So that's enough of me talking. I will pass over now to Anna, who can talk around the legal side of things. So over to you, Anna.
Thanks, Tim, and it's a pleasure to be here this morning. From my perspective, I've wanted to cover quite a few areas. You'll see them on the slide. Just in terms of managing expectations, the session at the very end in relation to employment law reform is fairly brief, and it's really focused on recruitment. Otherwise, we'd need another hour or so, or probably more than that, to cover off what the government is proposing to implement. So what I wanted to start with was avoiding discrimination in recruitment. And in terms of this, you know, you'll, I'm sure, be very familiar with the provisions of the Equality Act. Protection has been around for many, many years in relation to job applicants. So those with the 9 protected characteristics, so age, disability, race, religion, and so on, all protected in relation to the recruitment process, as well as once they're in employment. So that will give your potential candidates an opportunity, if you like, to challenge your processes, to challenge your decisions. And unfortunately, discrimination still seems to be fairly rife within the recruitment arena. So what I wanted to do was just to cover off a couple of cases, just to give a flavour for the challenges that employers face here. So the first case is a case called Lee against R&F Properties. And in this particular case, Miss Lee had attended an interview for a senior marketing role at R&F Properties. That was a salary of around about £68,500, which is quite relevant. In this particular case, she was actually offered the job following an interview. She was then asked to attend a meeting about a month after the offer had been made to her, at which point she'd also given notice to her previous employer. And so she was due to start with R&F quite soon after that sort of meeting. So during the meeting, she was asked by one member of staff about the ages of her children, which you might think is a slightly unusual question. One of her children was 4, one of her children was only 1. And 6 days later, that job offer was withdrawn. Now, R&F maintained that the reason that the job offer had been withdrawn was that they had a head office recruitment freeze, and that this was just effectively unfortunate timing. And in response to why Ms. Lee had been asked questions about her children, the response to the Employment Tribunal claim that was brought was that this was to build rapport. Well, the tribunal, unsurprisingly, didn't accept that as the reason. They found that asking a job applicant details about the ages of their children could be direct, and was, in this particular case, direct sex discrimination, because it was more likely than not that a woman would be asked that question rather than a man. And in this case, going back to the salary that was on offer, in fact, the tribunal awarded Ms. Lee £61,500 for loss of earnings and almost £30,000 for injury to feelings. So really important to think about how people are interacting in that recruitment process, even after an offer has been made, because of the implications of withdrawing the offer and the potentially sizable awards that could be made. So moving on to the case of Levy and McHale Legal. This is a case involving allegations of age discrimination. In this particular case, McHale Legal advertised for a solicitor. They asked for a solicitor to work in their commercial property team who had at least 5 years post-qualification experience. Mr. Levy, who was in fact the only candidate who applied, was 57. He was expecting a salary of around £50,000 a year, and the departing solicitor had been paid £42,000. He was told that the recruitment decision was subject to a board meeting, and the solicitor who had interviewed him attended that board meeting, explained that Mr. Levy was the only person who'd applied for the role, and in the course of making notes during that meeting, recorded, this is a quote, "expensive, doesn't cover our needs," quotes. So there was no negotiation about the salary that Mr. Levy wanted, and eventually the interviewing solicitor emailed him to say that the firm had decided actually not to offer him the job. They decided that actually it was more appropriate to look for a junior solicitor with between 3 and 5 years post-qualification experience, who they could, in the solicitor's words, mould to their own specific requirements. And not unsurprisingly, Mr. Levy brought a claim for age discrimination. The Employment Tribunal decided that the use of that word expensive was in fact synonymous with Mr. Levy being an experienced and older solicitor, and he succeeded with his claim for age discrimination, and at a remedies hearing he was awarded £13,000, which included £4,000 for injury to feelings. So, these claims are not necessarily cheap. The awards that can be made, if you look at Levy and look at Lee, can be quite sizable compared to the salaries that might have been on offer. So finally, just covering off a case in relation to disability discrimination. In this particular case, Farrow and Foster Clay Law, Miss Farrow was a disabled lawyer. She had IBS. She'd had what sounds like quite a difficult employment history. She'd started her life as a trainee solicitor with a particular firm where there were long periods of intermittent sick leave, which were related to her IBS. It was quite clear from the judgment that the relationship with her employer had become quite strained, and eventually she'd raised a grievance complaining of unfair treatment because of her IBS. She left. She then joined another legal firm to complete her training contract, but wasn't offered a position on qualification. She updated her LinkedIn profile to indicate that she was a newly qualified solicitor seeking employment, and at that particular point, Foster Clay expressed interest, and she was interviewed. In the course of a telephone conversation that took place, her IBS was discussed in detail, and the Employment Tribunal was prepared to accept that she was very forthright about her condition, and that was really because what she said she was trying to do was to avoid difficulties arising, such as those that had arisen in her previous first employment. Notes were made of the conversation, but not terribly comprehensive. Apparently her IBS was recorded as tummy issues, and there wasn't a really detailed account of what had been discussed. No consideration appears to have been given to whether or not IBS was a disability. And ultimately, Ms. Farrow said that she had been made an offer of employment. Foster Clay denied that, but the tribunal said that either way, the recruitment process was still proceeding, and it was accepted by the tribunal that the process continued to the point where Foster Clay requested references from her previous employers. Her first employer indicated that she had left over a grievance and that there had been lots of absence from work, which frankly should really have been a red flag. The reference from her second employer was, as you might expect, and this may be your practice, much more factual. The recruitment process continued, and then ultimately Miss Farrow was told that the process was going to be stopped. There was some issue about whether she could work from home, whether she could be properly supervised, and ultimately decision was made that the employment offer process wouldn't be taken any further forward. The firm maintained that IBS was nothing to do with this decision, but ultimately the tribunal found that, in fact, the email where the firm's decision was confirmed did indicate that, in fact, her sickness and her timekeeping had been an issue, and that was obviously connected with her IBS. And the tribunal felt that actually more should have been done to explore her condition, and rather than just simply make a decision not to proceed with recruitment, further inquiries should have been made. Now, her claim was upheld. She was awarded £6,500 for loss of earnings, nearly £17,000 for injury to feelings, and that included an element for aggravated damages. And in fact, interestingly, she was actually also awarded costs, which is quite unusual in the employment tribunal. So what about the concept? And we do hear this from time to time, the concept of best fit. Well, there's a case that indicates actually how difficult and actually how risky it can be to focus too much on best fit. In Clements and Guy's and St Thomas's NHS Trust, the claimant, Mr Clements, was in his 50s. He applied for a role as a project manager. He was interviewed. He was the best candidate. In fact, there were two best candidates. He scored 81.5 points in the process, and the other candidate, who was a woman in her 20s, scored 80 points. So there was then a process adopted by the trust where, notwithstanding Mr Clements' really high score, the panel decided to discuss who to select on the basis of who would be the best fit. And in order to actually determine that, they held informal meetings with members of the team where both candidates, or the successful candidate, would have been working. Most of the team were quite young and were quite female, and that was really quite influential in relation to the decision that was ultimately made. So comments were made in feedback that the claimant was too experienced or too senior, that he was very different from the previous incumbent, who had been a woman in her 20s, and his future manager indicated some concerns about how she would manage him. She would feel uncomfortable managing him as he had an 11-year-old daughter, that it was felt that it would be better to employ somebody at an earlier stage in their career, as they then could progress to develop their career over a longer period within the NHS. And again, unsurprisingly, Mr Clements brought a claim of age and sex discrimination, and the claimant succeeded. The tribunal decided that the focus on best fit was discriminatory, and he was awarded about £7,500. So I think in terms of best practice, and I'm sure all of you are very aware of this, it's really important to be very clear about the language that's used in adverts. It's very important to make sure there are consistent questions asked at interview, and that those questions are kind of tested to make sure that there isn't a discriminatory element sort of creeping in. Think about whether further inquiries need to be made, so particularly in relation to issues around health. And also think about how you frame feedback and how that might be interpreted. So moving on now to the issue of reasonable adjustments. I wanted to touch on firstly the disability employment gap, and perhaps this goes to some of the things that Tim was talking about earlier in terms of, accessing the best candidates. We know that there is a disability employment gap, so that's the difference between how many disabled people are employed in comparison with how many non-disabled people are employed. And those figures have been measured in the UK since 2013. And generally, the gap is running at around 30%. Although it's really interesting because last night on Channel 4 News, they reported that that gap had increased. They didn't give very much detail, and I've not been able to find anything this morning that's hit the press yet, but it'd be interesting to see, whether there has been a significant move. But what we do know from the figures from Q2 2024 is that there are about 5.5 million disabled people in employment, and that's increasing exponentially every year. So what might be the reasons behind the disability employment gap? Well, according to the Disability Rights UK body, they include things like lack of confidence amongst employers about employment, about accommodations, and about accessing schemes. There's also a risk in relation to skills and qualification gaps, which is caused by lower access to education and early careers opportunities, and also concern around inadequate support programs for individual disabled people and employers. So in other words, both parties being sort of disadvantaged. And there was some research published by the Page Group, and it's relatively old, it's back in 2021, but they found that almost a quarter of business leaders said that they were actually unlikely to hire candidates with known disabilities. And I think that creates a massive barrier when you're looking at adjustments, closing the disability employment gap, and so on. So I'm going to come back to some of the issues around concerns around cost modifying equipment and putting the right support in place and the fear of litigation and so on. But essentially looking at reasonable adjustments, the whole intention behind reasonable adjustments is that they are there to level the playing field. So it's to remove the disadvantage that the individual who has the disability faces in the job market. And it's the same test in relation to your existing employees in relation to the duty to make reasonable adjustments. Duty appears in the Equality Act. And it's really important, I think, to recognise that reasonable adjustments need to be considered at the outset of any recruitment exercise. The idea is that you shouldn't have any kind of practice that would put somebody at a disadvantage, or if you use that as for an example in the recruitment process, what sort of testing might you be requiring your candidates to undertake? Are there time limits to those tests? Should they be extended? Is that a reasonable adjustment? Is it something to do with your premises? So do you need to think about access to your premises? Do you need to think about toilet facilities or lighting or lifts or furniture? And also there might be some information in relation to auxiliary aids that needs to be thought through in terms of the recruitment process. So do you need any kind of text-to-speech software or braille availability or large font text in adverts or anything that you're posting online, to ensure that that's accessible? So in terms of knowledge, I think this is always a big challenge for employers, particularly at the recruitment stage. There is no obligation on a job candidate to tell you that they have a disability, but the obligation will arise if you know, or you ought reasonably to have known, that the individual is disabled and would therefore be placed at a substantial disadvantage. So in general terms, employers are not permitted to ask pre-employment health questions, but you're entitled to do that if what you're intending to do is to establish whether or not there are any reasonable adjustments that you need to make to the recruitment process. But again, there is no obligation on candidates to disclose. And from time to time, we do get challenges. I think sometimes line managers feel that they have been deceived because an individual hasn't told them that they have a disability, and they then need adjustments if they get offered a position. The same sort of issues that arise, I think, where a female candidate is successful and then on arriving in employment announces that she's pregnant. There's no obligation to disclose, and no action should be taken in relation to a failure to disclose, given that there is no positive obligation. So we would certainly recommend, when you're looking at this, adding a sentence into adverts, to ensure that candidates know that you're really happy to talk about adjustments, or invite candidates to contact you if they do require adjustments to be made. Asking in advance of interviews, for example, in an invitation letter, are there any adjustments that would be useful? And then even at the start of an interview, just double checking the position. And all of those steps are very much in line with the Equality and Human Rights Commission Code of Practice on Employment, which an employment tribunal will take into account. So the next question, I guess, for employers is, how do you know if an adjustment is reasonable? And that's a really tricky question because it's so fact sensitive. And ultimately, only an employment tribunal can actually decide. So what are the sort of factors that you would take into account? Well, you might look at whether or not making the adjustment would be effective in removing or preventing the disadvantage. You look at the practicability of making an adjustment. You might look at cost, and that's more likely to be in line with your own organisation's sort of financial resources. You might look at whether the size of your organisation is such that there will be a greater expectation or need to be making adjustments. And going back to the point I raised earlier, where there is this concern or perception that adjustments can be really costly, the reality is that many adjustments are very inexpensive. And in fact, asking the candidate to give you their perception, their details of their needs and so on is really important, because for most people with a disability, there will be a greater understanding of what they need to enable them to be able to participate. And then obviously once an individual is successful, if they've got a disability, there may well be support available through the Access to Work scheme. So what adjustments could you make during the recruitment process? Well, it really depends, again, on the individual's specific disability and what disadvantage might be experienced by them. But it might be things like application forms in accessible formats such as Braille or audio or large print. It might be allowing dyslexic job candidates, for example, additional time to complete written exams. Perhaps a candidate with Asperger's who's expected to answer a multiple choice test being given an alternative format. So, for example, short written answers. There's case law that confirms that that's the approach that should be taken. It might be about holding an interview in a meeting room on a ground floor. It might be about ensuring that the lighting in a room is appropriate. It may be about ensuring that the individual is offered a designated parking close to an office to be able to easily access the interview space. It could also be arranging interviews at specific times of day. So if an individual has a condition which perhaps means that they're more fatigued at certain times in the day, adjusting when the interview takes place. And in some cases, it could also be allowing the individual to provide effectively an oral submission to the job application rather than filling in an online form. So you can see that there are many different adjustments. And so we would be very mindful saying that there is a one size fits all, because frankly, there isn't. So in terms of practical tips, well, obviously, I'm sure many of you are very familiar with the government's Disability Confidence Scheme. Lots of support available there in terms of being able to look at how you can adjust and adapt your processes to ensure that you're accommodating the needs of disabled candidates. Perhaps building awareness, making sure that your willingness to have these discussions with candidates is clear from websites, using storytelling to demonstrate your organisation's commitment to the disability agenda, and perhaps approaching recruiting organisations who target disabled candidates so that you can have the best talent pool from which to select the candidate for the role that you're recruiting into. And then I think, providing training for recruitment managers and also for those who are going to be conducting interviews. So moving on now to positive action and kind of what it is and what it isn't. It's a voluntary lawful measure which is permitted under the Equality Act, with the aim of ensuring full equality in practice for people who share protected characteristics. And there's some government guidance that was published in 2023, and just quoting from that, that says positive action allows additional help to be provided for groups of people who share a protected characteristic, so race, sex, sexual orientation, in order to level the playing field. You employers, can take proportionate action that aims to reduce disadvantage, meet different needs, and increase participation. So turning to the Equality Act, there are two forms of positive action permitted under the Equality Act. And we have what's known as general positive action, so that's in section 158, and we have positive action in recruitment and promotion, which is in section 159. So looking at general positive action, section 158 applies where the employer wants to do more to improve diversity through formal means. And so firstly, the employer needs to consider whether they reasonably think that people who share a protected characteristic experience a disadvantage that's connected to that characteristic, or perhaps have needs that are different from the needs of persons who don't share those characteristics, or have disproportionately low participation in an activity compared with others who don't share that protected characteristic. So when it comes to reasonably think that one of those conditions applies, the employer needs to have gathered or analysed information on their workforce to be able to feed into one of those conditions. And then the employer can consider taking action, but that action needs to be proportionate. And if any of you are particularly interested in looking at this further, it's chapter 12 of the Equality and Human Rights Commission Code that essentially summarises what is possible here, where it talks about actions to remedy disadvantage, action to meet needs, or actions to encourage participation in activities, so the conditions that need to be satisfied. So you could have, for example, targeted advertising or targeted open days aimed at disadvantaged groups. That's not to the exclusion of people who don't share that protected characteristic. You could provide additional support or training aimed at meeting the needs of particular people with particular protected characteristics. You could look at reserving places on training courses for people with a protected characteristic where there's low participation from that particular group. But positive action does need to be kept under review, and necessarily it's likely to need to be time limited. And that's really because if it's indefinite and you've already met the needs, you've met one of those conditions that I've just mentioned, then it's probably no longer proportionate to continue with the positive action initiative. So very much about looking at what you might want to do. I would suggest, if you're interested in the concept of positive action, that you do take advice, though, because the line between positive action and positive discrimination is quite thin, and you could find yourself, and I'll come to a case in a moment, where actually the employer inadvertently committed an act of positive discrimination, not positive action. But just touching very briefly on section 159, which is the specific positive action in relation to recruitment and promotion. And this is basically, if this is going to be at the end of the recruitment process or potentially a promotion process, where the prospective employer has established that two candidates are equal. So it's a tie-break provision, and it allows the employer to treat one candidate more favourably because that candidate has a protected characteristic. But there are some fairly tightly prescribed circumstances where this would apply. It's only where there is a genuine tie-break. So these, you've got two candidates that are equal. And I suppose my question would be, how often do you, in your recruitment processes, end up in a situation where you have two candidates who are equal? If you think back to the Clements case, Mr. Clement scored 81, the younger female candidate scored 80, but that would not trigger a section 159 positive action entitlement, because they would not have been equal. So equal on merit, that's absolutely key, absolutely fundamental. And you can't have a policy of treating people who share a protected characteristic more favourably as a general policy. So every case needs to be looked at on its merits. And then if you are going to treat one candidate more favourably, that needs to be proportionate. And and there are specific provisions specified in the legislation that need to be considered. It's a provision that I have to say, since it was introduced, I have never seen used. So that might suggest that it's fraught with difficulty, and that line is very thin. Just touching very briefly on one of the cases in this area, and there are very few, Turner Robson and others against the Chief Constable of Thames Valley Police. It's a case involving involved a process where police force wanted to appoint, and did in fact appoint, a minority ethnic sergeant to a detective inspector role without undertaking any competitive recruitment process. 3 white British police officers expressed interest in the vacancy, but because it wasn't advertised, they weren't able to participate in the process, and they brought claims. The police force argued that it had moved the minority ethnic individual into the inspector role in accordance with its positive action progression programme, which it believed amounted to positive action within the meaning of section 158, so the general positive action provisions. The tribunal found that their failure to carry out any competitive process was not a proportionate means of achieving a legitimate aim. It went beyond that. It was more than mere encouragement, and it disadvantaged officers who didn't share the same protected characteristic, who were denied the opportunity to apply for the role. So it just goes to show how fraught with difficulty this can actually be. In terms of practical tips, if you're interested in this, obviously I've mentioned take advice, but this is going to be very evidence-based. You're going to need to identify your legitimate aim. You're going to be able to have to ensure that you can't find a less discriminatory way to achieve that aim. You need to think about the language that's used. Targets are not the same as quotas. And you need to be very joined up to make sure that everybody involved in the recruitment process is aware of what what the employer is trying to achieve here. So just moving on to equal pay, and this is touching on a very small part of everything that applies to equal pay, which is a particularly complicated area, but this is really just around material factor defences. So that's the defence the employer will deploy if they're sued for equal pay, and where market forces might be that specific material factor defence. So the Equality Act, as I'm sure you all know, requires that employees should receive the same pay and contractual benefits for doing the same job, or jobs that are of equivalent value, or where those jobs have been rated as equivalent under a valid job evaluation scheme, regardless of gender. So if we get into a situation where market forces is being deployed, it is and has long been recognised as a material factor defence, but it's really dependent on having compelling evidence, and evidence that refreshes every time you go through a process of recruitment, potentially, to justify any continuing difference and approach when you're looking at recruiting candidates. So the fact that you might have had market forces issues in the previous year, you may not have those issues this year. And also it needs to be kept under review because it can't be deployed as the defence sort of on an ongoing prevailing basis. So where there are pressures in the job market, so skill shortages, competitive pressures, the kind of things Tim was talking about earlier, then provided that that's nothing to do with the difference in sex, that could be a material factor defence. I mentioned the Next litigation because it's quite recent, but Next relied on a number of material factor defences. One of them was a market forces defence in relation to paying warehouse staff more than the basic pay that they paid to shop staff. This defence was in fact found to be tainted by sex because claimants in the roles that were carried out predominantly by women on the shop floor, you couldn't those jobs that were carried out by on the shop floor were predominantly carried out by women, and those in the warehouses were predominantly carried out by men. So that tainted that market forces argument. So it wasn't a material factor that could be successfully deployed because it was effectively indirectly sex discriminatory. However, the Employment Tribunal did find that Keeping retail salaries low was a way of ensuring viability within the business, resilience and successful performance of the business. So next, were entitled to pay staff differently in circumstances where they could justify that. And that was actually borne out in one example where triple time was being paid to warehouse staff who worked on public holidays, but only time and a half was paid to shop staff. And that was because Next were able to demonstrate that without paying triple pay, they would have struggled to find sufficient warehouse staff to work on public holidays. So those warehouse staff, predominantly men, that was accepted, that was a material factor defence. There's Equality and Human Rights Commission guidance issued in May 2021 that I would recommend you have a look at if this is an area of particular interest. And I think that we need to be very mindful about what we do when it comes to starting salaries and whether or not we can get comfortable that actually we will be able to explain that difference in a way that is not related to gender. So things to think about. I think we know that in certain circumstances we may have certain candidates who are more confident about demanding higher starting salaries, and they may be men. We know, according to the research, that women and minority ethnic candidates tend not to ask for higher starting salaries, and that's a concept known as the salary gap. Should you have a salary history ban? Do you need to ask about salary history? And it's interesting because in the US, certain states and cities across the US have introduced a salary history ban, and research that's come out following that those bans being introduced suggests that women receive on average an 8% pay increase, and Black employees in those cases were receiving a 13% pay increase. So there are lots and lots of different and interesting concepts to think about. So we might want to think about how we go about our recruitment processes from a pay perspective, and how willing you are, bearing in mind what Tim was saying about paying to get the candidate that you need, who's kind of demanding the higher salary, the 10% that Tim mentioned earlier, but be very mindful of the risk there of potential equal pay complications. So just moving on to AI and recruitment, I'm really conscious of time. So, we know that AI can be really helpful for employers in the recruitment process, generating job descriptions, perhaps identifying identifying job boards that can be used, screening CVs, ranking candidates, all of these things where AI can just make the process more efficient. And also when you get to onboarding, generation of automatic, template contracts and offer letters and chatbots to assist candidates or new recruits rather with, who have questions. The idea of the old FAQs document, but, getting AI to do that for you. So lots of benefits in terms of AI, in terms of saving cost. And for candidates themselves on their side, very easy to access generative AI to help navigate recruitment processes, write job applications, cover letters and answering interview questions and so on. So there are no legal risks. There are legal risks. I should say there are no specific legal provisions, no legislation governing AI in the UK at the moment, but I'll come back to that. The likely greatest risk to employers in the process of using AI is that it introduces discrimination into the recruitment process. So algorithmic bias, rubbish in, rubbish out. And Amazon famously found themselves having to scrap an AI recruitment tool because the tool taught itself that male candidates were in fact preferable to female candidates. You could get age discrimination issues creeping in. Will the AI favour, younger workers, perhaps because younger candidates may have a greater understanding of the AI processes. AI could impact on your DE&I strategies. Highly digitized processes could exclude people who aren't particularly tech savvy, who don't have access to technology. That could be due to age, disability, financial, socio-economic circumstances. So that gives rise to the risk of claims. And then, technologies may actually be quite inaccessible for some. And we know that facial recognition technology is also an issue, particularly in relation to neurodiverse candidates, where things like facial expressions, micro expressions, interaction can create some considerable issues. So be mindful of that too. The ICO carried out, so the Information Commissioner's Office carried out an audit in relation to AI, reported last year some of the worrying things around lack of accuracy, too much personal data, incorrect definitions. So it's really important, I think, to make sure that we are very mindful that the ICO is looking at the use of AI. And in terms of labour reforms, the government is looking at introducing safeguarding against discriminatory algorithmic decision making and invasion of privacy with the use of new technologies. So we think we are going to see some intervention and watch this space, because there's not a huge amount of detail at the moment, but we do know that it is high on the agenda. And then just touching on the Employment Rights Bill and employment reform, I'm sure you were all familiar with the fact that probably in the autumn of 2026, the qualifying period for unfair dismissal, which is currently 2 years, will be removed in its entirety. And that will mean that your new recruits will have unfair dismissal rights from day one. There will be a sort of light touch process proposed that will deal with how you manage those new recruits during what's being described as an initial period of employment. So that's a period of 9 months is the suggestion at the moment. And the idea is that you'll be able to dismiss candidates for conduct and capability, for example, using a light touch process. We have no idea what that light touch process looks like at the moment, but I'm sure any of you who've been in a situation where you're looking at dismissing a probationer will know how important it is to make sure you can justify that decision. So I suspect you'll still need documentary evidence. You'll still need to have some form of meeting with an individual so that it's clear that there are no discriminatory reasons that sit behind your decision to dismiss. But in terms of impact, more robust recruitment, getting the right candidate. I know that's obviously the aim of every recruitment process, but there are times, I think, where resourcing needs are such that it's a case of just getting people through the door and into work. So we may have a situation where employers will have to look more robustly at this, and of course that potentially impacts on your DE&I policies. Will managers want to take a chance on an individual who may not necessarily fit the complete bill? You might decide to recruit less, not suggesting complete recruitment bans, but you might decide to recruit less, and that will potentially mean that more work might need to be done by existing workforces, which cuts across some concerns that have been raised previously by the TUC. There's a potential here for mindset change in relation to more rigour in the process by interviewing managers, recruiting managers being really aware of how important it's going to be to kind of manage closely new recruits once in position, because of the fact they will have their rights intact, and then potentially, of course, more employment tribunal claims and a tribunal system that is already very under-resourced and is swamped with cases, which has never really quite recovered from the pandemic. And then I just wanted to finally touch on one of Tim's opening comments, which is this piece around, ongoing competition in the market. We know that people are still very keen on kind of hybrid concepts of working, flexible working arrangements that we saw emerge from the pandemic. Now, the new Labour government, or not so new Labour government, is proposing that flexible working will become the default position where flexible working is possible. Since April of last year, the right to request has been a day one right, but this is going to be a change. This is going to be essentially a right to work flexibly where that's possible. So I think we've seen lots of scaremongering, lots of media attention a few months ago with some of the tabloid press saying, people will, or employers will be required to meet the demands of employees wanting to work compressed hours. That's just not true. I mean, compressed hours has been an arrangement that's been around since the right to request flexible working was first introduced over 20 years ago. But I think there's likely to be an ongoing expectation of flexibility. So I would suggest that we watch very closely how the government decide to implement their desire for default flexible working from day one. No change is expected until sometime in 2026, but definitely an area that we should be looking to monitor closely to make sure that we are attracting the best candidates and that what we have on offer meets the sort of expectations of those talented candidates that we want to employ. So it's a real quick canter, and I think we've got 4 minutes, Tim. So apologies, but I hope that gives time for maybe 1 or 2 questions, and I'll pick anything else up separately and feedback through Tim.
Definitely. I think that was really helpful, Anna. I've been making notes and some really great takeaways actually for people to to take away. We do have so I think Vicky has asked a question. I would like to provide questions to every candidate ahead of interviews. Neurodiversity organisations like ourselves consider this to be best practice. Like Lexic consider this to be best practice. I'd like the legal point of view on this if possible. So does that make sense? So providing questions to every candidate ahead of interviews.
I mean, you could do that on the basis that then we're not making a decision about whether or not somebody is in fact disabled or not. I guess the issue is, from a legal perspective, if you're providing questions ahead of an interview, for example, to candidates who are neurodiverse or who have other disabilities where they need that adjustment to be made, that's permissible, because when it comes to disability, you're perfectly entitled to treat somebody more favourably where they have a disability than somebody who doesn't have a disability. I guess from the disabled candidate's perspective, would it be a concern that you might actually be giving an advantage to the person who doesn't have their condition? But equally, I think it's one of those areas where we'd want to be looking very closely at that as a practice to make sure that we're not inadvertently creating a disadvantage for the disabled candidate. I can't see in a neurodiverse situation that that's likely to be the case, because that candidate will actually benefit from having the questions ahead of time. I think the issue would be is, does it somehow create more advantage for the individual who doesn't have that disability?
That's great. Okay, thank you, Anna. I've got a couple more questions at the moment, but I think we're going to run out of time. So I'll just do one more, and you've got less than a minute. But would be great to see cases where employee has lost the claim against the employer based on alleged discrimination. This is from Rita.
I mean, there are certainly lots of cases where employees and job candidates even do lose cases. And a lot of cases, claimants will withdraw if they consider that their prospects of success are not great, or can be encouraged to withdraw. So we as lawyers will sometimes make cost application warnings where we believe genuinely that there is no reasonable prospect of a claim succeeding, to invite the claimant to withdraw. But there are certainly plenty of cases. If you go onto the government website, where you can find employment tribunal judgments, if you were to put in a search, for example, disability discrimination, you I'm sure will find a number of cases where claims do fail, and it's very clear because the tribunal's judgment will say that at the very beginning.
Thank you very much, Anna. Thanks for that. We're going to have to call it a day because obviously people have other meetings. Thank you so much for joining us. We've got 1 or 2 other questions. What we'll do is we'll type those up and send those with the slides anyway. And thanks again. Obviously, you can get in touch with Anna if you need any advice and got any other questions as well. As I said, thank you so much for your time, Anna. That's really insightful and very useful. Thanks very much for joining, everyone, and we hope to see you at the next webinar webinar when it hopefully continues to get warmer. So thanks a lot, everyone. Take care and see you soon. Take care. Bye bye now.
Thanks, Tim. Bye.
Bye.